But listen, Miss Pugh, don't speak over me. Miss Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen, Miss Pugh, stop talking over me. If you want to stop talking over me.
Where is the verified claim that is being placed against my trust?
You can go back with the bailiff. Go back with the bailiff. Get your own attorney or represent yourself if you don't like it.
Today we are looking at a tense courtroom exchange between a famed judge and a defendant using sovereign citizen-style arguments. She arrived with a small sheet of notes that appeared to contain familiar phrases often repeated in similar cases, as if she believed a few prepared lines could dramatically shift the outcome. It seemed like she expected those statements to override established legal procedure and bring the hearing to a quick end. Instead, the atmosphere quickly turned serious as the judge maintained control and focused on the actual charges before the court. Written scripts rarely substitute for a clear understanding of statute's evidence and courtroom protocol. When a defendant relies on rehearsed claims rather than substantive legal reasoning, the gap becomes obvious almost immediately. The judge remained steady and attentive, which set the stage for a direct evaluation of her arguments. Cases like this often highlight the difference between online legal theories and real-world judicial practice. Stay with us as we watch how this heated hearing develops and how the court responds to her approach.
Good morning. Are you Janetta Pugh?
I am the beneficiary of that estate.
You're the what?
I'm the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of that estate.
Okay.
For the record, I recognize Ms. Pugh. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right, so Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus, and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel, defective defense.
It's overruled. You're running out, aren't you?
No, it's fine.
This moment makes it clear that her strategy is falling apart in real time, and the contrast between her claims and the judge's steady composure is striking. The judge remains calm and attentive, allowing her to finish while maintaining full control of the courtroom. Many individuals who rely on sovereign citizen language believe they have discovered a powerful legal shortcut, yet court precedent has repeatedly rejected those arguments. Simply declaring a lack of consent does not erase charges or remove the authority of the court, because jurisdiction is determined by law, not personal belief. Watching the exchange unfold creates a mix of second-hand embarrassment and curiosity about how she arrived at this approach. She speaks politely and addresses the bench with proper titles, which shows an effort to be respectful, yet the substance of her defense suggests deep confusion. It raises broader questions about how persuasive online legal theories can lead someone away from practical guidance. The situation highlights the gap between scripted phrases and the structured reality of judicial proceedings. As the hearing continues, the focus will return to evidence, procedure, and established law rather than unsupported claims. Let us continue following the case as it moves toward its next critical stage.
So here's the thing, Ms. Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Ms. Pugh, don't
with my
speak over me.
incarceration- Respectfully, Your Honor, with my incarceration being
Ms.
involved-
Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen to me. Everything you have there is overruled. And here's one of the reasons why. Is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I do not agree or comply to your foreign
Go back.
agents.
You already said that, and that's overruled.
Is to the state.
Go back with the bailiff. Get your own attorney or represent yourself if you
That
don't.
exchange may have felt awkward at times, but the story does not end there because she returned to court on a later date, and that hearing adds another layer to the situation. The judge throughout this process has shown a notable level of patience while maintaining firm control over the courtroom. Addressing repeated sovereign citizen-style arguments can test any judge's composure, yet she continues to respond with measured clarity. Rather than reacting emotionally, she focuses on procedure and keeps the discussion grounded in established law. There are moments where her tone becomes sharper, which signals that boundaries are being reinforced, yet she still allows the defendant space to speak. That balance between firmness and restraint is often essential in hearings like this. Managing unsupported legal theories while preserving order requires steady leadership from the bench. As we move into the next court appearance, the question becomes whether the defendant's approach changes or if the tension escalates further. Let us step into the following hearing and see how the dynamic evolves from here.
So, Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of your appointed foreign agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today if that's what you want to do. We'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you? Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegation is from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I honestly anticipated that exact statement because after covering so many hearings involving sovereign citizen arguments, the patterns become very predictable. The repetition of the same phrases and claims makes it easier to see where the conversation is headed long before the words are spoken. While some of these situations can appear frustrating, it is important to remember that courtroom time and public resources are limited, and every extended argument affects the broader system. Judges, court staff, and law enforcement must allocate their attention carefully, which makes prolonged unsupported claims especially challenging. There's also the reality that some defendants may be navigating personal or mental health difficulties, which can complicate how they approach legal proceedings. During this appearance, she did not seem to rely on the same written notes seen earlier, which suggests either preparation or a change in strategy. If she chooses to continue representing herself, the potential sentencing range being discussed could place her at significant risk depending on how the court evaluates the case. Self-representation in a serious matter requires strong legal understanding and careful communication. Let us return to the hearing and see whether she proceeds on her own or reconsiders her options as the stakes continue to rise.
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself, by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I haven't did anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine after they listen to the evidence if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, just get ready like you would. Probably it's going to go straight onto a jury, and we'll just get it figured out that way. All right.
The judge handled this hearing with a high level of professionalism and restraint, and it is difficult to find fault in the way she managed the courtroom. She appeared to give the defendant multiple opportunities to clarify her position and ensured that the record reflected those chances before taking stronger action. The patience on display was notable because maintaining composure during repeated unsupported arguments is not easy. Even when the situation became tense, she kept her tone measured and focused on procedure rather than emotion. At the same time, there is something sobering about watching a defendant struggle publicly as the consequences of her choices become clear. The judge seemed committed to fairness and due process while also recognizing when the proceedings could no longer continue in the same manner. Moments like this can feel uncomfortable, yet they also highlight how the legal system relies on structure and accountability. Observing the defendant attempt to respond under pressure showed how challenging it can be to defend a position without solid legal grounding. Overall, the hearing demonstrated the importance of judicial patience balanced with firm enforcement of courtroom rules. Share your perspective on how the judge approached this case, and whether you believe the outcome reflected the effort she made to keep the process fair and orderly.